Hi, my name is Rodney. I'm founder of Rodney Employment Law, and I'm here today to talk about the coronavirus, otherwise known as COVID-19. The coronavirus is top of mind for most Canadian employers, and it brings to mind some of the recent unanticipated events of our past, such as the blackout, the ice storm, H1N1, and SARS. The difference, however, with the coronavirus is, one, the potential for widespread outbreak seems to be real, although it might also be heightened by the media. Secondly, the rapid growth of social media and the information that comes to our attention much more quickly than even 5 or 10 years ago has led to kind of a heightened sense of urgency for employers. So given that context, I thought what I would do is talk about three main things that employers need to be aware of and how to handle in light of the coronavirus. The first is if your employees need time off from work due to potential infection of the coronavirus, direct or indirect contamination. So with time off, there's two areas that you can get time off. First is your contract of employment may provide for some paid time off by way of personal time, sick time, vacation time, etc., or wellness days in some progressive companies. Those days can be paid, and those can be covered for days off if you're in quarantine. Alternatively, if it's not paid, the question is, how do you grant your employees time off? And most jurisdictions across Canada, and I'll speak about Ontario for example, have many different types of leaves of absence that are all unpaid but need to be granted if the employees meet the criteria. And in this case, they would, under family medical leave, family caregiver leave, and other leaves of that nature. So you need to be aware that the question is not whether to grant your employees time off or not. The question is, do you pay them? And that's where you need to look at the contracts of employment or the legislative requirements. Secondly, accommodation in the workplace. Everyone's aware of the duty to accommodate under human rights legislation, and human rights takes a very broad and liberal view to these situations. So when the SARS outbreak happened in 2003, SARS was deemed to be a disability under human rights. Similarly, I believe there's an argument that the coronavirus, if infected directly or indirectly, would be deemed to be a disability under human rights, thus triggering the duty to accommodate. That's something that employers do need to keep in mind. Similarly, with accommodation, if you go to a different country or you're from a different country, there may be racial or ethnic discrimination that takes place by attributing where someone's from to the infections that have happened in that country. And lastly, if you have to take care of family members, either immediate family or extended family members, there is a ground of discrimination called family status where employers would need to be aware of. And lastly, the third issue is, what happens if you have staff members or employees who aren't infected directly or indirectly, haven't traveled to these countries, but for whatever reason, due to paranoia, fear, or other reasons, are electing not to come to work? The question is, what do you do with these people? Do you discipline them? Do you coach them? Do you communicate with them and kind of give them different options? Do you allow them to work from home, with pay, without pay? So these are the kinds of questions that employers are facing today, which the cases are all on a case-by-case basis. So we would encourage, in this third scenario, of if your employees who aren't impacted are choosing not to come to work, what to do is to reach out to Rodney Employment Law for guidance and assistance. And we will continue to update all of you with information as it becomes available. Thank you.